At-will employment is a fundamental concept that shapes the employer-employee relationship in nearly every U.S. state. It means either party can end the employment relationship at any time, for almost any reason, with no advance notice required. This seemingly simple arrangement has numerous nuances that both employers and employees need to understand. At-will employment is the default employment relationship in 49 states, with Montana being the only exception. Under this arrangement, employers can terminate employees for any reason that isn't illegal, and employees can likewise quit at any time without legal consequences. This provides flexibility for both parties, but also creates significant power dynamics that affect workplace relationships. Despite the broad discretion at-will employment provides, employees still maintain important legal protections. Employers cannot terminate workers based on protected characteristics such as race, religion, citizenship, gender, age, disability, or sexual orientation. Employees are also protected from retaliation for engaging in legally protected activities like whistleblowing. These protections exist regardless of at-will status and are enforced through federal and state anti-discrimination laws. Many people misunderstand the scope of at-will employment. While employers have significant latitude in termination decisions, they cannot violate federal or state laws prohibiting discrimination and retaliation. Additionally, at-will employees retain rights to fair wages, safe working conditions, and eligible leave under laws like the Family and Medical Leave Act. The at-will doctrine does not strip employees of these fundamental workplace protections. Several important exceptions limit the reach of at-will employment. Written employment contracts that specify employment terms or termination procedures override the at-will presumption. Collective bargaining agreements typically include just cause provisions that protect union members. Implied contracts can also modify at-will status, though these can be difficult to prove in court. The burden typically falls on employees to demonstrate that an implied contract exists. The public policy exception represents another significant limitation on at-will employment. This prevents employers from firing workers for reasons that violate established public policy, such as terminating someone for filing a workers' compensation claim, refusing to commit illegal acts, reporting safety violations, or fulfilling civic duties like jury service. While 8 states do not formally recognize this exception, federal protections may still apply, depending on the circumstances. For employees, understanding your employment status is crucial. Review your employment documents carefully to determine if they explicitly state you are employed at will. Even without using the specific term at will, language indicating you can be terminated at any time without cause establishes this relationship. Conversely, employer policies requiring cause for termination may create enforceable rights even in an at-will state. The at-will employment model offers distinct advantages and disadvantages for both parties. Employers benefit from workforce flexibility, simplified termination processes, and the ability to quickly address performance issues. Employees gain freedom to leave positions without legal repercussions and increased job mobility. However, employers may experience higher turnover and reduced loyalty, while employees face job insecurity and vulnerability to sudden termination without severance or notice. When presented with an at-will employment agreement, employees should approach it with caution. While refusing to sign such an agreement could result in not being hired, it's important to clarify any discrepancies between the written document and verbal promises. Courts generally hold that signed at-will agreements supersede verbal assurances of job security or probationary periods. Getting all promises in writing provides the best protection for your interests. Employers drafting at-will agreements should focus on clarity and consistency. Use unambiguous language stating that employment is at will and can be terminated at any time. Avoid making contradictory promises about job security or guaranteed employment periods. Regularly update employee handbooks to reflect the at-will nature of employment and document performance issues even though not legally required under at-will doctrine. Several circumstances may override an at-will employment agreement. Union contracts typically include just cause provisions that protect members from arbitrary dismissal. Written employment contracts, specifying employment duration or termination conditions, take precedence over the default at-will rule. Public sector employees often have additional due process rights under civil service regulations. In some cases, courts may enforce promises of continued employment under the legal principle of promissory estoppel if an employee reasonably relied on those promises to their detriment. At-will employment remains the dominant employment model in the United States, balancing employer flexibility with employee mobility. While it grants employers significant discretion in hiring and firing decisions, important legal protections and exceptions ensure this power is not absolute. Understanding these nuances helps both parties navigate employment relationships more effectively and protect their respective interests.